Good morning, everyone. We'll, I just rescued you from a bad pen. I'm going to throw this out.
Take that one.
No, I'm going to throw it out. We'll be right back.
Got ink all over them with one of my pens. I've laid that one there in case you.
Oh, I'm fine. Apologize for the delay. We'll continue with the hearing on Senate Bill 42. For the members, we're not going in until 11 o'clock, just a reminder today. So it's my intent, again, this is hearing only today. It's my intent to see how far we get. We may be able to go ahead and get through our list of witnesses. If not, it would be our intention to go ahead and come back at 1 p.m. and meet from 1 p.m. until 2:30 p.m. In order to get through the line of witnesses, and we'll just see how it goes with the questions and Q&A with the various witnesses. Correct. We are hearing only, and we'll see how far we get to this morning and possibly this afternoon, and move on from there. With that, without delay, let me call on Mr. Wilson Dubose to come forward. Welcome. Let me ask you, if you would, Mr. Dubose, to err on the side. That's perfect, right there.
Okay. Is that good?
That's perfect. Thank you very much.
Good. Thank you very much. Good morning to everybody, and thank you for giving me the opportunity to speak today. And I feel like I need to speak both with respect to the specific matter before the committee, which is Senate Bill 42, but also, I think, to provide, some much-needed communication between the Public Defender Standards Council and the legislature. I think it's fair to say that, at least among some of you, we've been suffering from some bad PR, and I regret that. I regret that some members of the legislature feel that the council has been taking a hostile approach to the legislature and an indifferent approach to fiscal concerns. I'm here to say that from our perspective, we have done neither. While a very small minority of our members have been provocative in their statements, in their public statements, those views, or at least that style of communication, is not prevalent among the council. And a lot of the views as to what should be done with our public defender system that are held by those people are not shared by every member of the council, even a majority of the council. The council is a 15-person body, some of which were appointed by the judicial branch, the Chief Justice of the Supreme Court and the Chief Judge of the Court of Appeals, until that appointment procedure was changed by the passage of Senate Bill 1245, House Bill 1245 last year. All the new appointments are made only by the governor and the speaker and the lieutenant governor. The council has 15 members, 4 of which are appointed county commissioners, the rest of which are not required to be county commissioners, but they are required to represent every geographic area of the state by virtue of the original House Bill 770 that created the Public Defender Standards Council in 2003. So we have representatives from each of the 10 judicial districts throughout Georgia. and some of our current council members come from Baxley, Georgia, Albany, Brunswick, Lafayette, Ringgold, Watkinsville. I myself am from Madison. It is a diverse geographic group. It is a diverse, what I would say, political, ideological group. More than half of the members of the council were appointed by either the Speaker or the Lieutenant Governor or the Governor. More than half of the council would call themselves Republican, but not all, which is as it should be. We are well represented across ideological and political lines, across geographical lines, and with the appointment of the county commissioners, we are well represented vocationally as well. It's not just a group of lawyers. And let me say a few words about what the mission of the council is. And it's not just how the council members themselves perceive their mission to be, but it is what the enabling statute passed in 2003 declared the mission of the council would be. The statute says that the purpose and the mission, the primary mission of the council, is to assure the adequate and constitutional representation of indigent defendants, independent of personal or political considerations. That is what we are charged with. That is the oath that we take as council members when we become members of the council. I've been a member of the council since its inception. I was appointed by the Chief Justice, who's here today, the former Chief Justice Norman Fletcher, in 2003. There are other members of the council who have served for as long as I have, but we also have new members who have been appointed over the years. So again, we have diversity in yet another area, that is in terms of length of service on the council. But the one thing that I can say with certainty, in spite of the great diversity we have in so many areas within the council, is that the council members take very seriously their statutory obligation to assure as best as they can that Georgia, through the council, is providing constitutionally adequate representation to indigent persons accused of crime. Sometimes when we do that, it might appear that we are myopic, that we are maybe self-obsessed. But that's really not the case. Everything we do, we try to do with considerations of broader perspectives in mind. But yet everything we do has to come back to our primary obligation, and that is to assure the adequate representation of indigent defendants in Georgia. That is what we as a council are obligated to do, not just on behalf of these indigent defendants, but also on behalf of the state of Georgia, because Georgia has that obligation, whether the council provides that or whether some other mechanism provides that. Providing constitutionally adequate representation is a constitutional mandate, and it is going to have to be provided in one way or another, or else Georgia's criminal justice system will come to a halt. Providing adequate indigent defense representation is not an ideological or political matter. It's just a question of integrity to the Constitution. And it provides legitimacy to our entire criminal justice system when we have an indigent defense system that is serious about providing adequate representation to those whom it is required to serve. Now, part of our job in assuring adequate representation is to assure that the governor and the legislature, i.e. the decision makers in our state government are fully aware and apprised of what our council thinks will be required in terms of funding and in terms of operational considerations to do our job properly, to provide constitutionally adequate representation across the board. The major component of that obligation to the legislature and the governor is to tell you what we believe our funding needs will be based upon the cases that we are faced with on a year after year basis. We have tried to do that using the resources of our council staff. Every year since our inception, we have gone through an exercise within the council of having our staff, through their own internal deliberations as well as their consultations with our lawyers across the state. We have 43 circuit public defender offices across the state, along with 6 single county opt-out circuits. Each of those public defenders in those 43 circuits are consulted every year when it comes to determining what our budgetary needs are. The lawyers from our Capital Defender Office are consulted when it comes to determining what our budgetary needs are. And our internal central staff obviously applies their own considerable experience in governmental budgetary matters in coming up with what they believe our budgetary needs are. The council members themselves have never taken it upon themselves to determine what those needs are. We don't have the expertise, we don't have the time or the resources to do that ourselves. And we serve free. We aren't getting paid for it. Even though we serve free, we have devoted thousands, literally thousands of hours to helping try to make the system work over the last 4 years of its operations. It began operating January 1, 2005, by the way. So what we do from a budgetary standpoint, we take the recommendations of our staff, we deliberate over those recommendations, we ask questions, and we attempt to arrive at a reasonable yet sufficient level of funding that we think we need. And we try to advocate for that in the General Assembly. We have never taken the position that we are out to provide, I think the term used yesterday was an O.J. Simpson defense. That, even in our wildest dreams, we've never even considered that kind of approach. I think everybody realizes that what we're, or at least I hope everybody should realize that what we are here to do is to provide an adequate defense. And what is adequate? I think you measure adequacy, you have to measure it on a case-by-case basis. And that's what appellate courts do. But if it can be boiled down to a single sentence, I think you would have to say that an adequate defense is a defense in which a competent criminal defense lawyer satisfies the standard of care that would be expected of criminal defense lawyers handling the type of case that lawyer is handling. Again, you can't create a definition where you can have a objective criteria. It's obviously a subjective matter, and the adequacy is determined after the fact. But the purpose of our council is to try to bring to bear the resources that will make it as likely as possible that going into every case, we have lawyers who are competent, we have resources that are adequate to provide a competent representation and a fair representation to indigent defendants. I think much of the shall I say, unpleasantness that has arisen between the council and certain members of the legislature has arisen because of tensions caused by funding problems. When we are faced as a council with deciding whether to cut 41 positions because we no longer have the funding to pay for those positions, that does create tensions within the council. It creates a certain level of frustration within the council. But those are the kind of issues the council has had to deal with over the years. When we have been faced with whether or not to direct the council staff to pay those lawyers around the state who have been providing legal services for the council in our conflict cases and who have seen their bills cut by over 70% by our central staff because we don't have the money to pay them, that situation causes tension and, yes, a certain degree of frustration among council members. And that particular problem, we tried to deal with that by saying that it is not acceptable for the state of Georgia to ask people to provide services on its behalf and not pay them for it. Our action in directing those lawyers be paid, which occurred at our January 23rd meeting in Athens, has been, I think, mischaracterized as the council going out of its way to spend the agency's money so we will go broke. That is not the case. The money is there. The services have been rendered. The obligations have been made. We feel like the only morally and legally acceptable approach in that instance was to direct the staff to pay those bills and not continue to keep these lawyers uncompensated for the services that they performed. Just to give you one example of what was happening, I received a phone call from a young lady in Carrollton, Georgia, who had just finished providing representation for a murder case. The case was resolved, and her bill was arbitrarily cut to $1,000 for a murder case. Now, she didn't spend a lot of money to defend that case by conventional standards. She was very efficient in the way she handled that case. But her ultimate payment was barely 25% of what she actually spent on the case. These people have families to feed, they have mortgages to pay, and I don't think the council should be placed in the position of having to apologize for trying to see that they get paid for the services they render to the state when the funds are there. What we also did in conjunction with directing that those lawyers be paid was to direct the staff to come up with a supplemental appropriation request that would take the council through the end of this fiscal year. Because the director is right. If we paid those lawyers and if we paid the capital, the outside lawyers we hired to represent death penalty defendants in conflict cases, the council would have a funding shortage. But these people, again, had rendered the services and they deserved to be paid. And we thought that the responsible thing to do was to see that they did get paid and to request a supplemental appropriation from the legislature to cover the shortage, which we thought would be about $1.4 million. And we also felt that was justified because the fund that was created by House Bill EX1 in 2004 expressly and solely for the purpose of funding indigent defense in Georgia had collected far more than what the council was seeking. in its $1.4 million supplemental appropriation request. So the funds were there. The council has never been funded by general tax revenue, except in the first 2 years of its existence while this special funding mechanism was gaining traction. The last several years, the funding mechanism has collected about $14 million more than has been appropriated to the council just in the last 3 fiscal years. It is not true that the council has made a claim to every cent of that fund. We recognize it is not a constitutionally earmarked fund, yet we also recognize that in passing House Bill EX1 in 2004, the legislature was acting out on its desire not to have to fund the council from general tax revenues, but to establish a special fund to fund the council. And funding indigent defense was the only stated purpose of House Bill EX1. So when we say that we do suffer from funding problems, it's not idly made. If I can give you some example of the problems the council has had to face because of funding issues. In 2007, we had to make 41 permanent staff cuts. Dozens of vacant positions are still unfilled because of the funding freeze, in addition to the 41 staff cuts in 2007. I've told you about our staff arbitrarily capping the bills of non-capital conflict attorneys. There are also many instances in which capital cases, the lawyers representing death penalty defendants have had their bills unpaid. In some cases, the failure of the council to pay those bills through lack of funding has caused a delay in those death penalty cases, which creates problems down the road. Not to mention the immediate problems, but it creates problems down the road. We have had lawyers representing conflict defendants around the state asking to withdraw from their cases because they haven't gotten paid and because they have no confidence that they will get paid for their future work. In one county alone, the Superior Court judge recently granted the permission of 3 of our conflict lawyers to withdraw from 150 cases. That's one circuit alone. We have lawyers around the state who have signed contracts with the council to provide appellate work for the council. The need for increased appellate work or increased appellate lawyers resulted from a decision by the Supreme Court last year, the Garland case, in which it became mandatory to provide different appellate lawyers than the trial lawyer if an ineffective assistance of counsel claim was raised by the defendant. So we went out, in addition to our 2.5-person staff in the central office, we went out and contracted with 8 lawyers around the state to provide appellate work for our cases in which ineffective assistance of counsel claims have been raised. And now, this year, because of our funding issues, only 3 of those lawyers have said they will still work for us. Others have said we can't afford to do work without having the assurance of being paid. We have other conflict lawyers around the state who have said we are no longer going to work your conflict cases because we lack the confidence that we will be paid for our work. We have reached a situation where, in order to handle the conflict cases within our limited budget resources for those cases, our local public defender offices in our 43 circuits have really stretched the limits on what is and what should be a declared conflict. In making them do that, we are putting those lawyers at risk for guessing wrong and being told later by the Supreme Court that you violated your professional code of conduct by not recognizing a conflict and not properly dealing with it. And of course, we also run the risk, if we haven't properly determined whether a conflict exists or not, then an appellate court will determine it for us and decide a conflict did exist and reverse a conviction. We have reached the point where in order to live within the budget resources that we've been given, our clerical staff has disappeared. We have no clerical staff in our central office. We've been sued by defendants around the state for not providing death penalty representation. We've been sued for not paying our bills. We've been sued for not paying fees in a death penalty case. The cases, as I've said, death penalty cases in particular, have been put on hold while adequate funding can be obtained. The council has had to face these issues. I'm not complaining, the council's not complaining, but I want you to know that the council has had to face very difficult issues over the last several years of its existence. We have tried our best to deal with these issues in a responsible way. Just as an example, in the Nichols case, that case had been delayed several times because of the inability to fund the ongoing defense. The council itself came up with the idea of asking the trial judge to reconfigure the defense team in a way that would make it more economical to try that case. The trial judge accepted our motion and did reconfigure the defense team in the way that we had requested, thus enabling that case to finally go to trial and be disposed of. Again, I say this only to try to give you some indication of the practical day-to-day problems that our council faces in fulfilling its responsibility of managing this indigent defense system. It is regrettable that tensions and distrust has developed between certain members of the legislature and our council. I have tried to dispel that in every possible way. Last year, when the Legislative Oversight Committee of the council issued a report that's authored by Senator Smith, in which he said that I personally held extreme views, I wrote him and tried in a very respectful way to assure him that our council wanted a cordial and cooperative relationship with the General Assembly. And I say in that letter that I wrote to him, I have eschewed a confrontational approach and have consistently urged that we pursue a constructive and cooperative dialogue with the governor and the legislature. While you and I, this is Senator Smith, have disagreed over what level of funding our agency needs, it has been an open and honest disagreement that should not imply any disrespect toward you or other members of the legislature. Even though we do not always see eye to eye, I would very much like to have, and would like the council to have, a cordial and harmonious working relationship with you and the legislature. Please let me know what I can do on my end to help achieve that. I would be happy to meet with you at any time at your convenience, and would also like to invite you to attend one of our council meetings so that you can meet the other members of the council and see firsthand the types of issues with which we are confronted as an agency. I read that only just to try to give you some flavor of where I'm coming from as chair of this council. I am not a confrontational person. I don't think the vast majority of the members of our council are that way. And I don't think that the council as a whole should be judged by the actions of one or two members any more than this legislature as a whole should be judged by the action of one or two of its members.
Mr. Dubose, let me ask
Yes.
you if it would be all right. I wanted to make sure that you're had some freedom to make an extended statement, given the time that, of course, the author had yesterday. Would you be comfortable if we open it up to questions at this point, just in the interest of time?
If I could have about 5 more minutes.
Certainly.
Okay. There were many statements made yesterday by Senator Smith that I take strong issue with. But I think they can be boiled down to several different categories. One is the idea that this council goes out of its way to have an adversarial relationship with the legislature and the state. We have never voted as a council to sue the state. One of our members, because of, I believe, a deeply and honestly held belief that the bill that moved our council from the judicial to the executive branch was a violation of separation of powers, he did move the council at one of our meetings to retain outside lawyers to look at that issue and determine whether or not it would be feasible and desirable to raise that issue in a lawsuit. His motion to do that did not even receive a second. It died for lack of a second. At that point, one of our other members said, the issue of whether or not the move from the judicial to the executive branch was constitutional or not has been alive since that bill was first introduced. It ought to be resolved by an attorney general opinion. So that member of our council moved the council, and we adopted a resolution to request an attorney general opinion over whether or not that move was constitutional or not. The council never voted to sue the state. The council didn't take a position on whether we should be moved from the judicial to the executive branch. We want to do our job regardless of what branch we were in. But there's been a widespread perception, particularly among legislators, that the council actively pursued suing the state. That never happened. The motion to do that by one person died for lack of a second. Some of the other provocative comments that Senator Smith has referred to have come from that same person. And I'm not here to criticize or defend that person. He has a right to speak his mind, but that person is not the council. If you look at the overall makeup of the council and the overall way in which the council members have conducted themselves, you will not see any disrespect towards this legislature or the governor. I also want, again, to respond to Senator Smith's comment that the council has some notion that it is entitled to every cent that our funding mechanism collects. We've never taken that approach. What we have said is that the fund has collected sufficient funds to adequately fund our needs, and that those needs are not always adequately funded. Therefore, we do think we should receive the funds that we feel we need, and that we do believe that the funding mechanism has provided those funds without us having to go into general revenue to provide those funds. And with regard to the issue of funding, let me say this. The Public Safety Appropriations Subcommittee of the House Appropriations Committee yesterday did provide funding to help pay for some of these lawyers that I told you earlier had not been paid. And we appreciate the subcommittee's action in doing that, and we hope the full House will agree with the subcommittee recommendation to do that. We do appreciate that very much.
Mr. Dubose, I really do need to keep the wheels on the track. It's been a little over half an hour at this point. We haven't had a question yet, so I'm going to need to go ahead and kick it over to members so we can keep the process going. All right, Mr. Levitas.
Testimony. I appreciate you being here, and I had the pleasure of serving on an Indian Defense Study Committee with you, and I will add my comments that having reviewed lots of the minutes of the Public Defender Standards Council, yours has consistently, in my opinion, been a voice of trying to be a reasonable liaison between the legislature and the council, and has been an ameliorating voice for those what I would say are extreme views. I think anytime a member refers to what we're trying to do here as a legislative charade and murderous, that's an absurd comment, and I want to thank you for what you have done to try and be that as a leader, a good representative of your council, respectful of your members, but also respectful of the legislative process. So I would agree with you. It's a shame when the outlandish remarks of a few wind up casting so much doubt on the function of the committee. That said, there has to be some check on the system, the way it's paying out its members, and what is a constitutionally adequate defense. And I'm more interested in the procedural question, which is what methods are in place to either respond to those requests that have been made of you, and by you I mean the body, by Senator Smith, and to control and to check these costs, not just looking at bills and saying we need to pay people, but what formula do y'all have either in place or looking at right now to come up with some kind of standards for what will be a constitutionally adequate defense? And I understand it's a case-by-case basis, but there are certain standards that could be adopted.
Right. Well, the first thing we try to do is to make sure that we have competent attorneys and competent support people, either on our hired staff within our circuit public defender offices or a capital defender office, or those that we hire from the outside. So identifying and hiring competent attorneys and support people such as investigators, mitigation specialists, that's the first order of priority. The second is to make sure that these people have the resources that they need to mount what is would be considered a standard defense, not a O.J. Simpson defense, but a standard defense that anyone practicing in the area of criminal law would consider to be necessary for a case of that type. For example, the right expert witnesses, the right investigatory tools, testing, DNA testing, for example. We need to make sure that those resources are there to provide what any criminal defense lawyer practicing at a level that is considered not state of the art, but expected of a lawyer of that type, of that type of practice to provide. We also want to make sure that the caseloads are not so overbearing that they will be prevented from providing adequate representation. There are fairly standard, widely accepted standards for determining what the caseload should be. We have almost in every situation exceeded those caseload benchmarks in our circuit public defender offices. We have some lawyers in our circuit public defender offices who are handling 500, 800 cases a year, when in fact the benchmark for felony cases is 150, and for misdemeanors is 300 per year. So we've never tried to slavishly adopt these benchmarks, but we also try to make sure that things are not getting out of hand in terms of the caseload that our lawyers are expected to bear. It's not fair to them to be working on a very low salary to begin with, or in the case of outside attorneys, to be working at very low hourly rates. We're talking $45 an hour for most of the outside conflict defender work, $60 in court. $45 an hour barely covers overhead. And the salaried lawyers in our system are not paid at anywhere near what they could make in private practice in most cases. So we're asking people who are already being modestly compensated to really spend tremendous amounts of hours in order to keep the system running. There comes a point where we have to say enough is enough. It's not fair to you. It's not fair to the defender that you're serving. So again, we try to watch the caseloads, and that's been a big problem. Our caseloads have gotten out of hand, both in some of our circuit public defender offices as well as our capital defender office. We are handling about twice the number of capital cases that we should be handling with the lawyers that we have. We have about 5.5 trial teams in our capital defender office. We should, by normal standards, have 11 trial teams, and that includes the lawyers and the mitigation specialist and the investigator. So those are some of the things that we look at to try to determine whether or not going into a case we're going to be able to provide adequate representation.
Ms. Benfield. Mr. Franklin.
Well, yeah, I'm sorry. I was just, I still didn't hear the answer to Representative Levitas's question on, are there standards as far as the pay scale? I heard about the caseload.
Oh, as far as the pay scale?
Yeah.
Oh, I'm sorry.
Yes.
I didn't understand that.
I actually had another question, but I'm interested in the pay scale standard, so I'll ask that one.
Okay.
Is that correct? Is that what you were?
It's a little more detailed than that, but I know we've got to move on.
Okay. Our pay is approximately 80% of what the level of compensation is for prosecutors across the state.
If I may just follow, but are there standards in place or standards that you're working on in response to the oversight committee's work to manage the cost of the representation? I think specifically you're referring to outside counsel. Is that correct, Representative Levitas?
Yeah. Okay.
And I think you said 45 an hour for outside work, 60 an hour in court.
Yes.
Is that felony cases, or is that the same for felony, capital, and misdemeanor?
No, it's not the same for capital. Capital is $95 an hour.
And are there any other, if I may, are there any other measures you're putting in place to review these costs?
We are constantly reviewing these costs. Every time a bill comes in, it goes to our central office. It is reviewed by an experienced lawyer there for reasonableness. And we don't pay bills that are not reasonable. But in terms of trying to control costs more on the front end, which may be what your question is directed at, we are putting into place a procedure that will hopefully allow us to do a better job of predicting what our conflict costs will be, and to putting the conflict lawyers to hire from the private bar on notice of what they can expect, so that they will have an opportunity to decide whether or not they're willing to live within these guidelines. And they do establish presumptive estimates for 11 different types of cases. And it does provide a safety valve if the lawyer in that particular case, because of the exigencies of that case, feels that he needs to go over the presumptive limit for that case. And it does provide a mechanism for a review of that and approval for that. But this has been put into place, and we believe it will be beneficial and help us do a better job of being more predictive on the front end of our costs for conflict cases. Conflict cases, by the way, is really the tail that's dragging, that's wagging the dog. We have a few thousand conflict cases. The vast majority of our cases every year are the felony cases that are handled by our circuit public defender offices. About between 150 and 175,000 cases each year are handled by those offices, whereas the number of conflict cases that is really causing most of the problems number less than 5,000. this year.
Mr. Dubose, let me ask you a question.
Yes.
I had a conversation with the speaker yesterday, not about this, on a budget matter, and all kinds of numbers floating out there about what it is we're taking in as opposed to what it is that we need. Sitting at this table, Democrats and Republicans alike, we're looking at state government as a whole and what it is that state government must do in order to make ends meet in what I think everyone accepts 2009 to be, which is a survival year. This is a survival year. So when we're taking a look at what it is that we have and how we budget it, we're looking at state government as a whole. One of the key words that I heard yesterday was balance. We have to balance priorities versus what it is that we have, just like taxpayers, every taxpayer in Georgia has to do, and there's having that all too unpleasant, all too often unpleasant kitchen table conversation about what it is they want to do versus what it is that they have. Is it the council's contention that it operates, understanding, let me back up 1 second, understanding that the adequacy of a defense, like I said yesterday, is both a constitutional imperative and I believe a moral imperative as well. Understanding that, is it the council's contention that it must operate within the bounds of that balance, I'll call it, as every other state government agency / entity must do, or does the council consider itself to be different in terms of the sacrifices, tough sacrifices, admittedly, tough sacrifices that must be borne during a survival year? Does the council accept that it's on that equal footing, or does the council operate in general as if it's different? And if so, why?
The council certainly has done its share to contain its cost. We recognize that there is an absolute obligation on the part of the council to do what it is statutorily mandated to do in the most efficient manner possible. Having said that, it is also undeniable, and it's not the council's determination, it is the determination of the courts of this state and of this nation, that the obligation to provide constitutionally adequate representation cannot be dependent upon the transitory fiscal problems or fiscal situation of a particular governing body. There are cases, there are legion on that. Just last week, the Supreme Court of Georgia said the indigent defense budgetary considerations raised by the council in a case involving a defendant, a death penalty defendant in Burke County, says the indigent defense budgetary considerations raised by the council do not constitute a proper policy matter for this court. That's GPDSA versus state. In the case of Wilson versus Sutherland, the court said that the courts have the duty to ensure that crimes are speedily and efficiently prosecuted and that indigent defendants are effectively defended. Adequate funding of these functions thus becomes a constitutionally mandated. Garland versus the state, also involving the Public Defender Standards Council. The Supreme Court of Georgia said, in light of the constitutional rights involved, we find no merits in the council's budgetary concerns that it raises as warranting a different holding. On the federal level, Newman versus State of Alabama, the Fifth Circuit Court of Appeals, before it became part of the 11th Circuit in Alabama and Georgia and Mississippi, said it should not need repeating that compliance with constitutional standards may not be frustrated by legislative inaction or failure to provide the necessary funds. I read
So we're the problem.
I read these cases.
That's what I just heard. What I just heard is that the answer is yes.
No, you asked me a question.
Okay.
I'm trying to answer your question, sir, with all due respect.
Okay.
What I'm saying is, we are bound by these cases. The state is bound by these cases, and we are trying to tell you, as part of our obligation, what we believe is the bare minimum required in order for the state to satisfy its constitutional obligations. And the courts, not the council, the courts, sir, have stated that those constitutional obligations remain what they are, regardless of whether or not the state either has the ability to pay for it or has the lack of a desire to pay for it. I'm not accusing the state of having a lack of desire to pay for it. I know the state is having tough economic problems, but it is our obligation as a council to tell the state what we believe is going to be constitutionally required, and it's up to the state to, obviously, to make its own determination. But we've made a good faith effort to tell you what we believe is required based on the recommendations of our own staff.
Okay. And the credibility of that good faith effort, as you've defined it, is really what's in question here. And the question is who's in charge and who determines what is adequate. This is a funding issue. It is an adequacy of funding issue. And as far as I see it, it's a question of who's determining what is adequate within the context of the greater balance that I've expressed before. You have your position, and I appreciate that, and I respect it. The problem is that I fear that it may be just a little bit out of touch with reality in striking that balance. But I appreciate your position, Mr. Collins.
I have a question. It's often said around here we vote on words on paper. And what I have heard now for 2 days is a lot of discussion about bills. I've heard a lot of discussion about conflicts. I've heard a lot of discussion on who called who what and who names this and who names that. What I have not heard a lot of discussion about is how this bill, one, addresses, and from your comments today, and I appreciate your concerns, and appreciate that I have lawyers in my circuit who've not been paid, that those are all very valid concerns. What I have not heard, and frankly even from the author yesterday, is how this bill addresses that. And you've not spoken to this bill. You've spoken about your concerns of what you're currently doing. You've spoken about, the need for funding, and all those are valid concerns, but this is not an appropriations hearing. This is a hearing on a bill that changes the council from a council to an agency. Why is this bill bad in your opinion, or why is this bill good in your opinion?
Okay. Representative Collins, I am the first to admit that I have spent a lot of time on budget issues because I feel like that is really the 800-pound gorilla in the room, and that issue has done so much to affect the perception of our council within the legislature. So I wanted you all to know what kind of budgetary issues permeated our own actions as a council. But you're right, I have not spoken as to why SB 42 should or should not be passed. I don't believe that the passage of SB 42 in its present form is going to provide any positive benefit to the council, either in the short or in the long term. I don't believe a bill such as this should be passed based on momentary perceptions or hostilities that may exist between certain members of the legislature and certain members of the Standards Council. I do believe, however, that there should be some structural change to the management of the Standards Council, and I would ask that this committee consider adopting a substitute that basically has the following attributes. One, I think the council's policy-making authority should be maintained. There's a reason the council was set up to begin with as an oversight body. It was recommended by the Supreme Court Commission in 2002 that was established to review Georgia's indigent defense system. It is by far the predominant model around the country. Obviously, it is the only model for private corporations as to how they govern. You have a policy-making board, and you have people on the ground that effectuate that policy. We believe that is the proper way to do it. We believe that provides the appointing authorities the ability to bring people from around the state so that every aspect or every geographic area of the state can be represented and can have input into the way in which the council operates, rather than having a single person control not just the operations but also the policy making obligations of this agency. I think we need to restore the authority of the council to hire and terminate the director. That is the way it was set up in the original bill. We worked on the Legislative Study Committee, as Representative Littlevitis referred to a few minutes ago. The council had a very cooperative working relationship with its Legislative Study Committee. That study committee came up with House Bill 1245, which had a number of provisions in there that the council itself supported and requested. And in fact, the council either supported or had no position on almost every part of that bill, except after the legislative session ended last year, we found out that on the last day there was a change to it, unbeknownst to us, that removed the authority of the council to hire and terminate the director. That change, I regret to say, has resulted in somewhat of a dysfunctional relationship. Certainly it has resulted in some level of uncertainty by the director as to what the bounds of his authority are, and it also has resulted in some degree of conflict, maybe too strong a word, but disagreement between the council members and the director as to the extent to which the director should carry out the requests and directives of the council. There have been a number of situations in which the director has not done that, and we feel like that has created a dysfunctional situation, and we feel like it needs to be remedied by restoring the authority of the council to hire and terminate the director. And if the governor, who now has that authority, we don't have any problem with the governor having input and even consent authority over the ultimate decision of the council, both on the hiring and the termination side. We have no problem with that. So I would hope that we could restore the authority and actually have a compromise between what we used to have, which is sole authority by the council, and what we now have, which is no authority by the council, by having that be a shared responsibility between the council and the governor. I think the bill could also be improved if it was made explicit in the statute that the director has the authority to require circuit public defenders to carry out the policies and directives of the council. I believe that's implied in the statute, but there is no universal agreement that it is. And circuit public defenders around the state, at least some of them, do not share that view. We believe that the statute needs to be clarified so that it is clear that the director does have the authority to require CPDs to carry out the policies and directives of the council. We also think, at least I also think, I'm speaking in my personal capacity, that there ought to be a management study done to try to determine the optimum balance of authority between the council and the director, so that we can carve out areas where he or she should and can have authority to carry out the day-to-day responsibilities of the council without meddling and excessive oversight by the council. But there also should be some areas in which the council needs to be involved, and we think that it would be helpful to have that situation looked at professionally and to come up with recommendations as to where to draw that line. And I think it's obvious that we need a more constructive mechanism, Representative Collins, for attempting to try to reach consensus on the level of funding that is required to enable the state to provide constitutionally adequate representation. I think all the players need to make a good faith effort to get in the same room and to get on the same page. And I am very sorry that that process has not been a constructive process in the past. I hope that we can change that and can find a way to really just have a dialogue among everybody who's on the same side, which is what we should be, to try to find the best way to determine, both from the council standpoint and from the legislature standpoint, how we determine the adequate level of funding that is needed and constitutionally required. And I think that has to be done with the recognition that that level of constitutionally adequate representation is going to be required regardless of the state's fiscal situation at any given moment in time. Not that the council is demanding that, but that the courts are demanding that. Yes.
I apologize for interrupting, and we can continue, but I do have at least a thought. Yeah, I understand now that basically, from your perspective, we're dealing with an issue of I would say what I would call the military, more command and control. You're feeling that a 15-person body ought to have more, and from what it sounds like, control than a director. At that point, and like I do with most every person who comes to me to speak on a bill, I want to sort of turn the question. Tell me what's wrong with the systems that currently have a director in place that have a council that is more in line with sort of what we're looking at in 42. I understand you want it to go back to the way the world was, and I understand that. But what would be if you have I believe the council, in their honest opinion, has the best interest of the defendant and indigent care at heart. If that be true, is what would be the problems that other states are currently using a director with some input from a council? Is that totally an issue that would hurt indigent care in this state, or is it basically just the determination from yourself, and I'm speaking only from you, that this is the only way to do it? The way we had it was the best way, and we should never change it.
We all have our opinions on what is the best way, and I'm not here to tell you that if Senate Bill 42 were passed in its current form, that it would be per se unconstitutional. I don't think it would be. I'm here to tell you that it is my belief, having lived with this issue for a number of years, that the most responsible system is to have some level of oversight, rather than put all of the responsibility to both carry out the day-to-day duties of the council, but also to establish the long-term policies of the council all on one person. And I'm not speaking with regard to that particular person in office now. I'm speaking conceptually, not with regard to the present circumstances. And it is my firm belief that the model of having a diverse oversight group that represents every part of the state is far superior to having one person be in charge.
Let me remind members that we are going in at 11, not at 10 o'clock this morning, at 11. So we're going to continue on until 11 o'clock. To my friend from Gainesville, we have talked about funding a lot. Senator Smith talked about funding. Mr. Dubose has talked about funding. But ultimately, you're right. It's a command and control decision about striking that balance. Who is in the best position, given our experience, and that's all we have, is our experience and our budget, such as it is, in a survival year, as to who is in the best position to strike that balance. Is it the council, or is it the director? I mean, that really is what it comes down to. The gentleman's correct. Ultimately, that evolves or devolves, depending on your position, into a funding issue as well.
I absolutely understand that. I think the problem that I have is, and we could happily go along discussing that, but I think it was, from my question and perspective, the funding issues all come back to this issue of as we've heard yesterday, go ahead and pay these people. I think earlier the question was asked is how are you currently reviewing the bills? And I think just the honest short answer is it's subjective. We don't have an objective standard. It's subjective, and I appreciate that. I mean, my circuit does the same thing. Our judges get the bills, they look on it and say, oh, no, thanks, you're not going to get that, and they turn back the bills. Those are the kind of things that are there. I think what this issue is in the big focus is on how do we see, and it did concern me, your last statement, do I believe it to be unconstitutional? I'm interested to hear, not in a long thing right now, on how moving to this would be unconstitutional.
I'm not saying it is. I'm saying it would not be. It would not be unconstitutional.
Okay. The way the inflection was is a question.
Oh no, I'm not at all saying that, sir.
Okay.
But I am saying I think it should be modified.
And I appreciate that because I think we just focus directly on that. So.
Mr. Knox.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. I guess we're all trying to grapple with what it is we're trying to do in this bill, which is what we do here. That's what we do in the legislature. We write the laws. And, you know, to a certain extent, I'm a little bit concerned that that's been one of the problems that we've had with the program from day one, is that some of the folks that are affected by it don't understand that even if you don't like the law, that's what it is and that's what you have to comply with, because that's what the legislature does. You may argue with whether we do it very well or not. Well, most people do, but nonetheless, that's the fact. So that's what we have to deal with. And, you know, judges are in here and they'll tell you probably with things that they do that almost nobody agrees with them all the time either. That's part of being a lawyer and probably part of being in the justice system. That's one, you know, as soon as you finish your statement and sit down, the other lawyer stands up and says you don't know what you're talking about. So that's one of the things we're dealing with. But nonetheless, I want to see if we can agree on something, and if you would agree with this, that the bill that we have could very well be what we're going to be dealing with. And that being the case, do you have any recommendations, suggestions, or ideas on how y'all would go about, however y'all are constituted then, what y'all would do in order to implement the goals of the defense office and the goals of the legislation that we've passed? Have y'all given any consideration of what you will do in the event this is passed, and how you'll go about continuing the program, providing the services that we authorized, and so on?
Well,
that's a long question. I hope your answer is not as long as my question was.
I don't think it will be. If the bill is passed, the current council is abolished, and there will be a new appointment process that will appoint an advisory board to the council. It won't be called the council anymore. It'll be called the agency, public defender agency. And
I guess I'm working on the assumption that at least some of the members may be members of whoever the successor, whatever the successor body is.
Board.
Yeah. That being the case, assume you were one of them. I'm asking you a hypothetical now, but assuming you were one of them, what would you be saying to the folks who are going to serve with you? Here's what we need to do.
I think I would first say that we still need to have the same concerns at heart that we would have as members of this board that does have authority still. I think we should do what I think we are trying to do now, is work cooperatively with our director to advocate what we think our needs are, and to really act as if we were still a member of this council in terms of trying to be helpful in helping the agency achieve its statutory responsibilities.
Okay. So I guess what I'm trying to get at is that, what I'm hoping is that y'all aren't wed to this notion that we set up this one particular way of delivering services to indigent defendants, and that there's not a better way to do it. There's not even a different way to do it. This is the best way that everybody in the world knows is the best way. Because what I'm saying is I think we're past that now, and we're making a decision based on this legislation that at least the legislature so far, to the extent this bill has come to this point, is saying we don't think this is the only way, or maybe not even the best way to do this. Would you agree that that's where kind of what the politics of this are and the process that we're in?
Well, certainly the issue before the legislature is to determine whether or not the method presented by Senate Bill 42 is a better way than the current method.
Okay.
I disagree that it is a better way, but obviously I acknowledge that it's your decision to make.
Okay. Would you agree or not that it's a simpler way of doing it? And let me explain what I'm talking about. The best way to not get something done is to do it by committee. And we're sort of trying to address that issue, I think, in this legislation, is that we think that some of the problems that we have with delivering the service have to do that we had a committee running it instead of somebody that could be responsible and in charge of it, and doing it in a simpler way. And so I guess what I'm saying is that if we're delivering this service, we've made this sort of complicated, I think, by having 15 bosses. I think Representative Collins is sort of referring to that too, and that I think that may be part of the problems that we've had, and that's what we're trying to address here. In a way, all that this legislation was supposed to have done was to put a lawyer with a client. Just that simple. And when you boil it all down, that's all this is about. And really, that's all we have to do under Georgia law and under the code of ethics, under the rules of the bar, under the requirements of a lawyer's license. That's all that's necessary to be able to accomplish the goals of this program, and make sure that somebody who can do a criminal case can be available to defend somebody who has the need for that. And all the rest of it is administrative and bureaucracy and so on and so forth. You agree with that?
That obviously is the core responsibility of the state. I do believe that responsibility is better fulfilled when we do have an oversight body like we have now.
Right. Let me. I mean, no disrespect, because I'm somebody that believes in persons having a right to counsel and having adequate counsel, and having adequate tools to provide that counsel, including investigators and experts, which is probably what the defense bar lacks more than lawyers. I've made this argument before. We didn't have a shortage of lawyers. We had a shortage of money for experts, witnesses, and for investigators to help prepare cases, particularly felony cases where that's much more necessary. And so I guess that's where I'm trying to come at from this, is that what I would be hoping to hear from y'all is that if this legislation is enacted, you'll help us find some way to provide those essential services where they're needed, and in a way that is not in a way that isn't the way that we've been doing it. I guess I suppose that's the best way to say it, and that's what my initial question was, that how would you go about addressing that issue? Because we still have we're not abolishing the program. We're just saying we're going to try to do it a different way. You understand what I'm saying?
I do, and with all respect, I feel like if Senate Bill 42 came to pass, I have every confidence that those who serve on the advisory board would do their best to try to help the council or the agency and the state fulfill its obligations. I keep going back, though, to the fact that I think it is more effective over the long term and from a management model to have the kind of board that we have. Maybe it needs to be smaller. Perhaps it does. But that is designed to create a better, more effective operation for the council in the long term. I realize there may be transitory issues that may cause people to feel otherwise, but I think as a long-term model, that is the way to go with these modifications that I've suggested.
Mr. Dubose, thank you so much for appearing here this morning.
Thank you very much.
Let me ask former Chief Justice of the Georgia Supreme Court, Norman Fletcher, to come forward. If
Mr. Chairman, I regret that I have an arbitration to be at 10:30, so I am not going to be able to attend the rest of this meeting, but I appreciate the opportunity to appear.
Thank you for appearing here this morning. Justice Fletcher, it's a
Chairman,
pleasure. It's a pleasure to have you here.
Thank you.
Welcome, and we know that you were a pivotal part of the debate way back when, and which was really not that long ago. And we appreciate your service to the state then, and now, and prior, and in the future.
Thank you.
So it's a pleasure here. It's a pleasure to see. It's a pleasure to hear from you.
Thank you very
to give
much.
us some broad-based scope and perspective on what it is we're looking at. How we got. I'd be very interested if you, and I realize you have some comments you'd like to make, and we certainly welcome them.
Sure.
At some point, I would welcome your perspective on how we got here. You know, how did we get here, and why? I'm hesitant. I think we're all hesitant on both sides of the aisle to take a simplistic approach to how we got here. That would be the easy way. that being said, all we have is, as a judge, you know this. I mean, all we have is the evidence before us, and that is leading us in a particular direction. If there's something we're missing, and we reserve the right to miss something, let us know. We're not effective if we suffer the sin of pride around here. You just can't do it. So with that in mind, I appreciate the indulgence there, and thank you again for being here.
Thank you. I think all of you would have to agree, after listening to Wilson DuBose, who is a man of great character and great ability, who is very dedicated, that probably the wisest thing I did when I was Chief Justice was appointing him to this council. And he is a very reasonable person who has cared and worked very hard. I would like to address, if I may first,
Sure.
this bill itself, because that's what Representative Collins was mentioning, and he asked, why wouldn't it work, or why is it? Well, I will point out something that Senator Smith, this bill itself and what's before you is not a decision about whether it ought to be in the judicial branch or in the executive branch. That decision has already been made. This bill is about how you're going to run the agency. And I noticed Senator Smith did not say anything about how it's done anywhere else in the country. And the matter is, truth of the matter is, this system is not done in any state in this country. And
Could I ask you? I apologize. Could I ask you to lean forward just a little forward, more closer, a little closer to the mic? Thank you very much. Thank you. I'm sorry.
Echo. I'm sorry.
Thank you. No.
I appreciate that. But that's really the fact of the matter, is that there is no other state in the country that has this system. And to try to address that, for the past 2 years or so, I have served on the National Right to Counsel Committee, which is a committee that was put together several years ago through the Constitutional Project in Washington, D.C. And by the way, the co-chair of that committee is William Sessions, who was a former federal judge in Texas and who was director of the FBI for a number of years. And this committee includes people with judicial background, law enforcement, prosecution, defense experience, scholars, and a big cross-section. From the prosecution side, the man that served actually was the president of the National Prosecuting, I'll call it council for lack of a better word. And what this committee did was to examine what's in place and what has been done over the past 10 to 15 years across the country, and look for what the shortcomings are and how to make it work better. And as we found that, frankly, by using all of the resources that we have, that the biggest problems involved are the problems that you see, which is lack of funding, too heavy a caseload, and a lack of independency, and the resources that Representative Knox was talking about, a lack of those resources. And we this committee and this report is now final. I think it would be a great benefit to the legislative body if you had it and you could study it this summer. But with regard to the specific things that are in this bill, after going over everything, the recommendations that the committee came up, they break the recommendations of what states should do, what the federal government should do, what individuals and bar associations should do, and what could be done through and is being done through litigation. And by the way, throughout this country, there's litigation in probably more states than not, all affecting indigent defense and the systems that are set up. But in answer to this bill itself, this is what states should do, and this is recommendation number 1. States should establish a statewide, independent, nonpartisan agency headed by a board or commission responsible for all components of indigent defense services. The members of the board or commission of the agency should be appointed by leaders of the executive, judicial, and legislative branches of government as well as by officials of bar associations and board of commission members, and board of commission members, and they should bear no obligations to the persons or department heads or bar associations who are responsible for their appointments. All members of the board of commission should be committed to the delivery of quality indigent defense services, and a majority of the members should have had prior experience in providing indigent defense representation. The second, and then there's a commentary, and it gives you the reasons and the resources why this has been, why they've come to this conclusion. They're not saying that the makeup totally of the advisor of the board, that's oversight committee, but they're saying this is the way and this is where it's worked best. And in all of the resources that throughout the country, there is not a single one that has the executive director that does the policy making and the administration and carries everything out. The second recommendation, and it fits, and I didn't know this subject was coming up when I served on this board. I mean, and I did not write this, but the second recommendation, the board or commission should hire the agency's executive director or state public defender, who should then be responsible for hiring the staff of the agency. The agency should act as an advocate on behalf of improvements in indigent defense and juvenile defense representation, and have the authority to represent the interest of the agency before the legislature pertaining to all such matters. Substantial funding from the agency should be provided by the state from general funds. The fourth recommendation, the board or commission, and this is something I think Representative Levitas was touching on, but the board or commission should establish and enforce qualification and performance standards for defense attorneys in criminal and juvenile cases who represent persons unable to afford counsel. The board or commission should assure that all attorneys who provide defense representation are effectively supervised and remove those defense counsel who fail to provide quality services. And the fifth recommendation, the board or commission should establish and enforce workload limits for defense attorneys which take into account their other responsibilities in addition to client representation in order to assure that quality defense services are provided and ethical obligations are not violated. So actually this study, and it is documented with footnotes about every source of information they have, and it actually was trying to think of what the right term, I used to call it secretary, and that's not what it is, but the person who actually compiled it all after all of the studies is the reporter. Thank you. That's why the reporter has been a long-term professor, former dean at the University of Indiana Law School, and is a man that has studied this throughout the country. Also, I must be candid with you, the same man who worked in helping compile the facts and the data that we used here in Georgia, served on this committee too in helping get data together. But in answer really to this bill itself, everything that this national committee that's been studying for over 2 years comes from a broad spectra of society, says that this is the best. And every state, I've looked at this information, I cannot find a single state that has an executive director who does not have an oversight board over that is setting policy. It would be like, to a certain extent, like doing away with the Board of Regents and letting the Chancellor make all the policy decisions. It would be like the same thing with the Department of Natural Resources.
Do you want to start that conversation? Some people are trying to start that conversation.
Yeah. If you've got an enlightened dictator, it works well, but without that, these things don't work well. It's like whether you had a single commissioner form of government, which we had in Walker County and I represented for a long time. Fortunately, we had the enlightened sole commissioner, very fortunately. But so insofar as that is concerned, all of the studies, I would urge you, and I know, and I think if we go back to my last State of the Judiciary address in 2005, I said we would have startup problems. Every new agency does. And one of the biggest problems that happened is this aberration of the Nichols case came along in less than 3 months after the organization came up. And it has created a lot of problems, and I understand. I also know that the council has worked very hard to try to, when they see that things are going wrong, they're trying to make changes in their own policies to try to run the most efficient system possible. I have been around the state quite a bit because I don't have to work. I'm enjoying working still off counsel in a law firm in Rome, but it gives me time to do what I want to, like coming down here to be with you. But I've talked to judges in South Georgia. I've talked to them in Bartow County. I've talked to them in our area in the Lookout Mountain Circuit. I was with Andy Fuller in Gainesville last Wednesday discussing the new system, and Andy was a former district attorney before he was judge, and he says that the new system is working efficiently and effectively. And Shep Howell, judge in Cartersville, told me in December that he was one of the Superior Court judges that thought this idea of setting up this system was faulty. He was against it when it was done, and he told me, he said that he was wrong, that the system has worked very well. Yes, it has some problems, but it is moving people out of your county jails and those that need to be out there quickly, it's taking them out. And the cost of maintaining your city and county jails are so high, and the cost of maintaining as your prisons. But I was just reading in the paper about the audit here in the city of Atlanta, and they were saying that they are renting out space in the city jail for $65 a day to the federal government and some other agency. And this audit shows that it costs them $86 a day to operate the jail. The state of Georgia pays $45 to $50 an hour at least to private providers of prison services. So what I'm saying is it's helping the counties and the local sheriffs to get those minor misdemeanors, such as traffic offenses and all, who don't have someone. It gets them out within about 2 days, so you're not having to build more and more cells. And it's I haven't found, and I'm sure there would be, but I've talked to a number of sheriffs, and I haven't found those, at least outside of the metro area, and I haven't talked to the metro area, but I haven't found any of them that don't feel that generally this system is working much better now, that it needs what county commissioners want, I think, is more state funding than just on them. And frankly, every time the state funding is reduced, it just throws that burden right back on county government. And so there are many things I have great respect for Senator Smith, but and I agree with some of his statements, but I think his information is faulty on some things that he bases his conclusions on. And I don't think that's what you're interested in right now. So now you did ask me, Mr. Chairman, about this, how it was set up originally, and just exactly. And I will give you the best of my recollection of everything. Actually, there was a dire need in Georgia, because everybody recognized that in many areas the systems were totally inadequate. They had contract attorneys that, if you actually looked at their caseload, they were being paid $5 to $7 a case. I don't think there's a lawyer around that can say, or anyone in law enforcement can say that you can provide any representation for that. You can't even talk to them and plead them for $5. There's just no way in time you can keep the overhead of your office. And it was, judges were doing the best they could with the monies they could get out of counties to try to solve the problems. But this fragmented system was broken, and sooner or later it was going to be addressed by the federal courts, if not by the state courts. And so a commission was put together. It was a broad-based. It had legislators. It had DAs. It had people from all walks of life really in it. And then we were able to find the resources. After they had public hearings, we found the resources then to hire professionals who could go out and gather data from around circuits around the state. And based on this data and all the conclusions, this committee came together with a commission report that was unanimous. There were no dissents on it, and the recommended changes and how to do it. As to how this particular one was set up, the bar, I drafted a bill, others drafted a bill, then the legislature drafted a bill. And the bill that ultimately was passed was a bill that took some of the advice of the commission, but it was also a bill that was legislative that legislative leaders had drafted. Originally, it talked about the major thing that I had problems with in the original draft is that you were going to have the public defender for each of the 49 judicial circuits was going to be elected. He would run for, I don't know what platform they could run on to say, I'll work hard to free all those accused of crime. I mean, you know, and by the way, that was what then Speaker Terry Coleman wanted. And we had a long discussion, and some of his leaders in the Judiciary Committee were jumping on me, and I was telling them how it did not work around in other parts of the country and the problems they had. And when I was asked, all right, would you rather have the bill that's here or no bill at all, I thought a few minutes and said, under the circumstance, I would rather have no bill at all until you rethink this on electing the public defenders. And I really sweated that one too. I was, so this was a bill that came together really through I would say a good cross section, because we had on the commission people from the Democratic side and the Republican side. Chuck Clay was a big advocate for it and was on the commission. The senator from Albany, who has the long name,
Michael Meyer von Bremen.
Yes. He was on it. They were both. They worked.
The long name, I think, kicked in there.
Collaboratively on this, and we came up with what looked to be a good thing. And I still think it's a very good thing. I still think it has worked well. I'm sorry about any conflicts that have been there and misunderstandings. I know, I don't mind calling his name, that Wyke Orr, whom I've known a long time, his inflammatory language has incensed people. And I agree, that's not the way to get things done. And I wish Wyke hadn't done it. But the council as a whole, Standards Council, has not done that, and they've taken their role very seriously.
Justice, thank you. And let me make it clear. I think I speak for everyone that we're looking beyond the egotistical, arrogant rantings of the few.
Yeah.
And
thank you.
I knew you would. Are trying to focus on, and sometimes that's hard in this environment. Right. But we are doing that, and I think Mr. Collins put it best when he said this is really a management issue, and it's a management issue in the context of the balance that we have to strike. Again, understanding the constitutional imperative, understanding the moral imperative, understanding what the case law says, and also understanding that we may be taking in $600 million when we should be taking in $1.6 billion on a monthly basis, and that in the context of a survival year. Not minimizing any of those, and understanding that members of the council many members of the council are trying to do the right thing, but we just may have a dysfunctional outline skeleton of an operation that we have to go ahead and adjust. And the question is how to adjust that in the context of that proper balance. Let me go ahead, if you don't mind, and kick it over to questions so that we can do it before we go in. Mr. Knox.
Thank you. Judge, good morning. Good morning. You know, we're all familiar with that French saying, as much as I hate to quote the French on anything, but, you know, there's a statement, you know, saying that the more things change, the more they stay the same. I don't know what it is in French, but you probably know that. I don't. I just know what the translation is, roughly.
I know "Comment allez-vous all."
Oh, good. Yeah, let's leave it at that. I know a few of those too, Judge. But anyhow, you know, because a couple of the remarks that you made me think about some of the problems that we're having with the program. Because unlike some of the members, I think there are problems with the program that go beyond what we're addressing here that we really need to get down and grapple with, and we may disagree about what they are, but that doesn't mean we shouldn't have a conversation about them. One of the issues that has come up and as the reason that we went to the program that we had, which I think originally you would agree was that this state program would cover everything and everybody. We didn't have any notion of any opt-out counties or any alternative delivery system or any of that sort of thing when we initially began down this road to establish a program. Would you agree with that?
Actually, I recall that very early on, Chuck Clay, I believe, was the one who insisted there be some opt-out in, and I know that the bill that initially passed had an opt-out provision under certain circumstances.
Yeah, and those were very, very extremely limited and mainly out of political considerations rather than any consideration consistent with what the notion of the bill was. Would you agree with that?
I think part of it was political considerations, and part of it was and it did provide oversight. That I can understand why you should have or could have some opt-out provisions, but also, even with opt-out provisions, those systems need to adhere to some of the standards, and everyone should have standards that are. We're talking about caseloads. They should have generally the same type of standards, and if they would not adhere to those, and I think that was the idea of what was put in there initially.
Right.
And also, I don't think the council ever, I may be wrong on this, but at least within 2 years, I don't think the council ever denied a request for withdrawing from the state system. They still get their monies, but from the states, their pro rata shares, but I don't believe any of them were denied after.
They were originally.
Yeah, the first year.
There were a number of them that were denied and had to go back through the process. Right. Actually, we had to pass some legislation in order to allow some of those folks to opt out. But we had this. The premise of this is that counties weren't willing. I think this is it. That counties weren't willing to pay to provide sufficient funds to provide adequate or effective assistance to council. That's the whole genesis of this, whether it's here or some other state. Would you agree with that?
I think the counties had problems, and particularly in the resources area that were required by the Akey, Oklahoma case, which is resources that are necessary for expert witnesses and for investigation and that type thing.
That may be a discussion for another time, but we hear the same thing about everything in some counties in Georgia, that no matter what they're asked to do, they can't afford to do it. And that may or may not be the case, but when they've all come to us and said they want to be considered as a county in this geographical area, and when you do that, you accept certain responsibilities, and part of that is to provide certain things like attorneys for indigent defendants in your county. And so we're still at this point having that same discussion, only now we're having it with the state program and the county, whereas before it was just the county didn't want to do it, and they still don't want to do it. So some of them still don't want to provide that kind of funding. So to a large extent, it's about dollars and cents. The same folks who didn't want to provide it then still don't want to provide it now. They're perfectly willing for the state to do it, but they don't want any part of it. Would you agree with that?
I would agree partially with that, but it's not just about dollars, because you do have to have oversight and you do have to have standards. And in states around the country, we've found that sometimes just throwing money at it does not solve it if they don't have to adhere to standards and don't have oversight.
All right, I want to ask you about standards then, because standards are only applied by attorneys who are under this program. These standards only apply to attorneys who are hired by the that work for the state Indigent Defense Office.
As far as I know, that would be true, because they don't, under the legislation is now, I don't think they have oversight over the what is it, 9 or 10 that have 8 or 10 that have opted out.
All right, but I'm making a distinction here, because your assumption, I think, is that all indigent persons are now represented by attorneys who were either hired by the state program or are paid by a county opt-out program of some kind.
Well, I know not all, because the state does not provide the resources for your state court programs, although some of the counties have opted to fund additional help in their district public defender offices, so that they would take over the state courts.
Here, let me cut to the chase. What I'm really getting at is that whether it's a county or a state program is not the issue. The issue is that the council has pretty much revolved around this idea of setting standards for the defense of indigent defendants. Correct?
It's standards and caseloads, and to see that it's efficiently operated so they get the quality at the same time, considering the cost that's involved.
Okay. My point is that none of this has anything to do with the person who hires an attorney on their own to represent them, does it?
That's correct.
This doesn't apply to them at all.
That's right.
My question is, if this is that important, why don't we have legislation to say that anyone who represents an indigent defendant has to comply with these particular standards that this council told us that anybody that's doing representing indigent defendants should comply with.
That probably would make good sense.
All right, and so is it your idea then that we can't rely on the bar and on the licenses and the professional requirements that are already imposed on attorneys in this state to make sure that they do what they're supposed to do in representing an indigent defendant or any criminal defendant?
Let me ask you, I probably don't understand part of the question, but are you talking about people who have hired their own independent attorneys?
Yeah, absolutely.
All right. Well, frankly, most of them are not indigent.
Yeah, but it doesn't make any difference whether you're indigent.
And then that's up to that person has selected their attorney, and then it's going to be up to a court later on to see if they have violated the Sixth Amendment and the standards under Washington v. Strickland that the U.S. Supreme Court set.
But would you agree that this is not a standard that's imposed because these folks are indigent? These standards are being.
It's a standard that's imposed because that is what is required of the state or the local governments when the person is indigent who seeks them to provide the counsel.
Well, why is it?
I've got.
Right.
Let me just ask you to wrap it up so I can get to.
Let me
Mr.
ask
Levitas
you.
and Mr.
I'll try it one more time. Why should these standards only be necessary for someone who's indigent and not for someone who isn't indigent?
I think the standards should be the same. I think everyone should have quality. I'm not talking about a Eddie Garland, a Don Samuel, or a Jack Martin, but I think because the process is so complicated that if most of us in this room, in fact, if I were accused of a crime, I would not want to represent myself. I would have a fool for a client, and I think everyone deserves competent counsel. But at the same time, if someone elects to go out and hire their own, I don't know much you can do about it. But the risk it is run is whether there will be a reversal because of a inadequate, ineffective assistance of counsel.
I don't think we've ever seen. I don't know if we've actually got any good case law that would give you any comfort that you'd be successful on a claim like that on appeal in this state.
There was one that I wrote in December of I think it was of 1990 involving a death penalty. We sent it back on our own motion for a review by the trial court and hearings on ineffective assistance of hired counsel. And after it went back and was there for about 3 years, the trial judge came back and made about an 80-page ruling saying that it was ineffective assistance of counsel in that particular, that it was not. It was, and gave reasons. It came back to the Georgia Supreme Court, and by 4-3, we affirmed her decision. But we did send one back in a death penalty because, frankly, if it sat there in the normal process, the issue was going to be addressed sometime. And appellate counsel was the same as the trial counsel, and of course he did not raise the issue that he was ineffective.
Mr. Collins.
Thank you. I appreciate so much your passion on this issue and what you brought, and you brought up a dear friend of mine as well, Judge Fuller, in Gainesville, known for almost 20 years. I think the one of the things that was mentioned yesterday that has concerned me is it called in this, and I've talked about this before, that when elephants fight or big animals fight, the only thing that loses is the grass. And what's happening here is I see our local public defender's offices feeling as if they have done something wrong a lot of times because they have to just dealing with on the state level, we're not doing this, we're not getting this money. And bottom line, they're doing a good job. And the ones, I have a public defender in our area who is an excellent attorney. He is providing a wonderful service for those folks up in our Brad Morris. He's doing a good job. In a very tough situation. I think the problem that we're seeing here is that I've had the chance to speak to public defenders and assistant public defenders in certain areas, and I think to take all their statements into one was, at this point we don't care who we work for, just get it straight. And whether it's a counselor or a director, just help us out. And I think that was my issue that I'm looking at here. I appreciate your concern. You're talking about how we set this up. I think there is a lot of discussion in the legislature about the boards, and you brought up the Board of Regents, which is a sensitive area here. I think the question comes in bottom line is what is best for the person who's in need of an attorney. That basic right that we have, which I believe fully, and also believe that we need, if we do hire contract lawyers, at some point in time they have to have expectations of what they will be paid, which is reasonable, but also that they are paid and not out there on their own. I want to follow up in that question. Now, I've heard what you said. I appreciate. I'll take that into my consideration on this bill. I want to follow up on a question though that is dominated this on the money issue, and that's ineffectiveness of counsel claims, which on almost every appeal is thrown in sort of. Let's throw in ineffective of counsel and see what happens. And I appreciate your decision in the death penalty case. However, what we're seeing as well, even when the system had $5 and $7 an hour, as you made mention to earlier, in things less than capital cases, an ineffective counsel claim, even under your court, was never upheld. It was just basic. I mean, there may be onesie-twosies here. Are we throwing that out almost too loosely? Because, as Chairman Knox said, we don't have a good case law back up on anything other than capital. When we get down to felonies, and especially misdemeanors, they're rarely taken up by the Supreme Court. They're rarely held on any appeals level. But yet we use it in committee meetings like this to say, oh, if we don't do this, ineffective of counsel. Could you address that for me, sir?
Well, yes, and there are many that feel that the U.S. Supreme Court needs to reconsider the low standard that it set in Strickland. The Strickland standard is so low, but the reason I think that it's raised all the time is that if you don't raise it on direct appeal, then you've waived it, or there's a procedural bar later in a habeas case. And so, frankly, I used to wonder why are they raising it, and then after a while I was educated by the courts as to why it's done, and it's done because the procedural bars, or the high bar you have to get over as to why it was not raised earlier. But the standard in Strickland, there are people around the country now looking at that, trying to find the right vehicle to really get that issue back to the U.S. Supreme Court.
I understand, and I think you've made a great statement there, and you sort of made my point. It's a very low, the standard is set in Strickland very low, but yet even our own Court of Appeals and Supreme Court, even under your leadership, never found an ineffective assistance claim, even in it was because it was so easy to claim.
It's very seldom. I noticed Judge J.D. Smith wrote something the other day where the Court of Appeals did find ineffective assistance, but it is rare. It is rare.
Judge, I appreciate that.
Thank you.
We'll wrap up this round with Ms. Benfield. Before we do, let me just announce we will go ahead and continue at 1 o'clock. Our first witness then will be Jeff Bramlett, President of the State Bar of Georgia. It'll be our intention to go ahead and wrap up testimony by 2:30 p.m. this afternoon. Ms. Benfield.
Thank you, and I just have a quick request and a quick comment, because I used to do a fair amount of appellate work, contract appellate work, and you do have to raise ineffective assistance of counsel to get most claims even before the court. But I did win, too, on motions for new trial, and I'm just wondering how, I think quite often when there really is a glaring ineffective assistance of counsel claim, it's going to be resolved at the lower motion for new trial level.
At the trial level, where the trial judge has actually been the one sitting there and observing and seeing it on a cold piece of paper, which is what the appellate courts get. It's harder to get the emotion and feel
exactly. And I just have a quick, first I want to thank you. I really appreciate you lending your expertise to the committee. And I just wanted to ask, you did say you would be willing to provide a copy of the commission report, and I would love to see that. I think that would be very helpful.
I will call there tomorrow when I get back to my office at call Washington and ask for some copies of it, because I think it would be very informative. No matter what you might do now, it could help you as you go forward with things.
Thank you.
Because it is a resource of where you can get all sorts of information.
Justice Fletcher, we really appreciate your time and your wisdom.
Well,
and your service to the state.
I think I give more time than wisdom, but I appreciate you have a hard job. I understand that, and you have a hard job of balancing everything, but I appreciate the fact that you listen to old-timer like me, and I appreciate
we would be foolish if we didn't, and old-timer is all a state of mind as far as I'm concerned. I'm relying on that, as a matter of fact. So,
thank you very much.
Thank you, sir. We'll go ahead and adjourn now and come back at 1 o'clock, barring any unforeseen gymnastics on the floor. We'll see you at 1 o'clock. Thank you.